Welcome once again to The Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, the long-running program that we have continues to provide legal information, practical examples, some practical assistance to help you with the law matters, because as we say, the law matters. A better understanding of the law makes you better prepared to decide how to handle your case, and if you should decide to seek outside professional counsel, you'll be better prepared, so will the counsel you retain. Our goal, as always, is to help you save time, money, and achieve the best possible results. As always, we want to welcome and thank, once again, Attorney David Bazar from the Bazar and Associates Law Firm in East Providence, as he continues to weigh in on the issues that we tackle each week. And today, we're going to talk about the Supreme Court, its work, and its procedures. So how does a case actually reach the Supreme Court? How does it make it to the docket? What actually happens once it does? It's a long process, as we understand it, and it makes sense that it would be, considering it's the highest court tribunal in the land. So we'll talk about the various petitions, the writs, the briefs, the opinions, all the details, how they work. We have our legal eagle here to help us break it down. So we understand that they're the final arbiter of the law, and they, every session, have some very controversial cases. This session is supposed to be blockbuster, one being abortion and another one certainly being the Second Amendment. So how does that all affect us? First, we'll start with the primer. So David, let's talk about the Supreme Court. How does it work? How does a case get to be before the judges?
The typical way a case gets to the Supreme Court is through a series of appeals. The case is usually first heard at the trial level in the district court, the United States District Court of whatever state that the case may be brought. If the result in that trial is such that one side or the other wants to appeal, then it goes to the Circuit Court of Appeals for whatever district or region that the case was heard. And then from there, the case can be appealed to the U.S. Supreme Court, usually by a process called writ of certiorari. Writ of certiorari is an appeal to the court, and the court will then look at it and decide whether or not it's going to accept the appeal or grant the writ of certiorari so that the case could be heard by the court. So I'm not sure of the numbers, but of the, say, 70,000 or so cases that might be appealed to the Supreme Court, only a handful, maybe 60, 70 at tops, are ever granted writ of certiorari and are heard by the court.
Funny you should mention that. I just saw a set of numbers, 80,000 and 2.8%. Now, how current that is, I'm not sure, but that certainly is not far afield from what you're saying. So from the time someone has a case to the time that it gets even to be petitioned to the Supreme Court, what kind of time frame is going on? You mentioned several steps and appeals. How long might that take, Dave?
Well, from the time the case is first filed at the trial level. So it's actually a pretty quick process compared to many states where there are probably many, many more cases filed at the trial level. So a case is filed at the trial level, and in Rhode Island, for example, the case is then assigned to a district court judge and magistrate, and there's a process, the discovery process or the process prior to trial, where the side is getting information from the other side, just like any other case that's filed at a trial level. Interrogatories, requests for production, requests for admissions, whatever else might be filed at that level. So there's a process. In federal court, that process is pretty quick and compact. There's also a requirement at the federal level of some kind of alternative dispute resolution. We've discussed those before. It could be mediation, it could be arbitration. It can take whatever form the parties agree to and that the court sanctions. And so I would say all in, it could be, again, pandemic aside, 6, 7 months of pretrial and so forth, and then maybe a couple of motions and summary judgment motions, and if those don't get granted, then may end up on the U.S. District Court judge's calendar for trial. It could be done all within a year, probably, depending on the complexity of the case and everything else that's going on.
When you think about what actually makes the docket, we hear about, and they talk about, and I mentioned at the top of the segment, the blockbuster, Second Amendment, and abortion. The ones that are, if 80,000 are being proffered, is it because of the content or the procedure? What seems to make its way through that process? Certainly not everybody even gets to that place, even though there are 80,000 petitions.
Yeah, so the court will look at both the content, or maybe call it the importance of a case, and also the procedure as to how the case got there and what's involved with that. So the rule is 4 judges out of the 9 on the Supreme Court have to agree to grant certiorari on a case. So that means 4 of the justices have to say, there's an important enough issue here for us of precedential value or other value that is important for us to take a look at and accept the case for a full hearing. And so I think they call that the rule of 4. And that means that if 4 justices agree that a case needs to be given a full briefing and a full hearing, then that's how the case gets granted for certiorari.
Is there still an occasion where there's only 1 judge that's required, as in a stay of execution or something, if they just grab one right before they pull the plug or
So there are
inject the needle?
certain cases that come up that come through on a procedural basis, such as a request for a stay of an injunction or a granting of an injunction or some other kind of emergency relief. Sometimes that's referred to as the shadow docket.
Yes.
And so that usually, each justice is assigned to a particular circuit. And so if a case comes up through that circuit and the one justice who's assigned feels it's something that either he or she can deal with alone because it's just not something that the rest of the court needs to hear, they can deal with that on their own. But if it's something, even if it comes through the shadow docket, so to speak, that is of enough importance that they want the whole court to weigh in on it, then the whole court will weigh in on it. And the most recent one, which caught all the attention, was the Texas abortion law.
Yes.
And that case was brought up on a request for a stay of injunction, a request to keep the law from being implemented in Texas. And 4 of the justices, the whole court weighed in, 5 of the justices said that because of procedural reasons, really, they weren't going to grant that stay and they were going to allow the law to take effect, whereas 4 dissented and said, no, this is of such constitutional importance, we should grant the stay while we decide the procedural issues in it. And in that particular case, the procedural issues were really this. The law, as it was written, it was convoluted. And Texas took a great deal of time and steps to create a law that wasn't being enforced by the state, but rather by individuals. And the Supreme Court, in looking at that, said, how can we stay a law for the state? This is the 5 who said that they couldn't. That isn't enforced by the state, but rather by individuals, and the case isn't being brought against the individuals who are going to enforce the law. And the one individual who was in the case signed an affidavit that said he wasn't going to enforce the law. So the 5 justices who decided on the side of not staying or granting an injunction against the law going into effect said, we don't have the proper parties in front of us to be able to grant that. The 4 who dissented said, this is such an important constitutional issue that we should grant a stay in an injunction against the state or allowing the law to go in effect while we sort out whether or not we have the right parties and figure it out from there. And so that's why that case was decided the way it was, and on this shadow docket. And the complaint among many legal scholars is a case of that import, and in many cases that get decided on the shadow docket shouldn't be done that way, because for the most part, they're just a granting or denying or granting of the injunction with no usual written decision like you would get on a full brief of a case that certiorari was granted on.
And yet it is going to the Supreme Court in the larger sense, and they talk about, you mentioned, the constitutionality of the R v. Wade. Our Constitution mentioned abortion where? Not exactly, but everything is about interpretation. So question number one, we know that the issue about how we will be able to and when we will be able to and what the specifics are about bearing arms, Second Amendment, constitutional. Abortion, not specifically mentioned. How does that play out when you talk about the constitutionality of Roe v. Wade?
Right. Well, remember when we're granting certiorari on some cases, and in that particular Texas law case, some of the issues with the judges were, well, do we have jurisdiction over this? And they were very careful to say, we're not going to weigh in on the constitutionality of that law. That's not what we're talking about on that Texas case.
Yes.
But in general, if you want to go back to Roe versus Wade and how the court decided it was a protected liberty under the Constitution, and it's interesting, I think we may have even spoken about this before, but Ruth Bader Ginsburg, who was very supportive of the right to make your own choice, really felt that Roe versus Wade was actually decided under the wrong principles of the Constitution. Mm-hmm. And she would have actually have decided it under the equal right protection for women to be able to make their own choice, and was very thoughtful in how she would have gotten to that decision. But it was basically decided under the right to privacy, which is not something that's written into the Constitution, but has been interpreted for decades and decades and decades, centuries perhaps, of what is protected in the Constitution and in the Bill of Rights. And so it's considered to be a privacy issue under Roe versus Wade.
And also they're talking about the interpretation of viability. There's an issue now about 6 weeks, 15 weeks, after 15 weeks, and that is a subject of interpretation, and they may end up discussing that. But when it comes to their decision, their opinions, even if there's a dissenting one, address the issue about their power to enact the law or to make good or dispense it, because there's the Supreme Court, but there are issues that it would have to be taken care of at the state, each of the 50 states level. Address that.
Well, so if it's a constitutional right under the federal Constitution, the Supreme Court has absolute power and authority to interpret the Constitution and apply it to a set of facts. That's what they did in Roe versus Wade. They said this is protected, this is a constitutionally protected right, and we will prohibit states from passing laws that violate the U.S. Constitution. And that's what the decision in Roe versus Wade was, that the law as it was written violated the Constitution. So as you know, there have been many, many, many cases that have come up through the years with a little tweak of the language here and a tweak of the language there. And year after year after year, when these cases come up, the Supreme Court has always upheld the ruling in Roe versus Wade, but applied it perhaps a little differently to this set of facts or that set of facts. And maybe there was a little chipping away of it here or a little chipping away of it there, but overall they always affirmed the decision that was originally held in Roe versus Wade. And on another note, as you might know, certain more recently appointed Supreme Court justices have always said that, or they would not overturn Roe versus Wade. So I think maybe part of your question is, do they have the authority to overturn Roe versus Wade? So I'll answer that. There have been Supreme Court precedents that subsequent Supreme Courts have overturned. The one that comes to mind is the original separate but equal that was then overturned by Brown versus Board of Education. And they said that that did not apply anymore because it was never able to be enforced or applied equally. And so Brown versus Board of Education said, no, I think it was Plessy versus Ferguson, I'm not 100% sure, no it wasn't. But whatever the separate but equal was overturned by Brown versus Board of Education. So under the right circumstances, the Supreme Court has reversed itself. In this particular case, the justices have said that they wouldn't do that, but that doesn't stop them from chipping away in certain areas as they review cases that come before them.
And so every person who lives in any state, while they're watching what the Supreme Court may or may not decide, chipping away or how overturning it or whatever, various states have taken their stand. Laws protecting or restricting abortions. There are charts on who's affected, who's not, and there are laws explicitly protecting right to abortion in such states as what in our area, Rhode Island and Massachusetts and Connecticut and California. And then there are those that we talked about, I think in previous discussion when the Texas and the Mississippi story first hit the news, the trigger laws that once Roe v. Wade fell, that would absolutely trigger, and you know it's mostly the southern states, there are others, but mostly the southern states that are going to be impacted immediately. So even if the Supreme Court overturns it, Rhode Island and Mass right now are going to end up saying we're states that have the explicit right of protection. Not going to affect us right now. Might it affect us later on? So
I think what you're saying, did Rhode Island pass the codification, so to speak, of Roe versus Wade as a statutory law?
Sounds good. Go with that. Yes,
okay.
Yes.
All right.
Sounds
so
right.
Many states that were concerned about the Supreme Court undoing Roe versus Wade, which would basically mean they're saying that the right to choose is no longer constitutionally protected. So now it does go back to the states to decide what
exactly.
is right or not right in each state.
Yes.
So many states, Rhode Island among them, from what you're telling me, and I do think I remember this, passed laws before the Supreme Court has acted saying we are codifying the rights granted under Roe versus Wade so that your right to choose is statutorily protected in our state.
States' rights, yes.
State right. Other states will not pass that law. And since the law is passed, the only way then to undo it would be for the legislature to undo that law that they passed.
And without this being a political issue, we can say that the dynamics of the Supreme Court have been called into question, recent elections, appointments, whether President Biden is going to vote to, or try to have additional members appointed. Is it not the Congress of each state, our state legislature, that is supposed to watch what's going on, issues about guns, abortion, and isn't that why it ends up eventually at the Supreme Court? Because each of the states, for whatever reason, didn't quite write it airtight, so Texas can question this. Mississippi was another one to question, another facet of it, as you termed it, chipping away. Is it really our states that are, I don't want to say at fault, but isn't it the onus on the states in how they have written the law?
So, in states where they have legislatures and governors and folks that want to take away the right to choose, they have for years and years written laws to do that. And I think right now, in front of the Supreme Court, you mentioned, I think it's a Mississippi case that Mississippi has really written a law intentionally. They knew it would be a violation of constitutional rights under Roe versus Wade, and they keep doing this hoping that they can get their case in front of the Supreme Court and that eventually there'll be a court that is aligned with that kind of thinking and does do away with it. So here's how the Supreme Court works and how Constitution works in laws. A state, for whatever reason, will create a law. And if that law, and it doesn't have to be abortion, it can be anything, Second Amendment, gun rights, and, the prohibition of carrying weapons or whatever.
Concealing.
If the law is written in such a way that other people who are being affected by it think it impacts their constitutional rights, the Supreme Court is entitled to weigh in on whether or not a law passes constitutional muster, so to speak. Is the law constitutional or unconstitutional? And so if the Supreme Court finds that there's a case that comes in before it by that writ of certiorari type of process that they need to weigh in on because it doesn't seem to, well, at least 4 of the justices think there's an issue that they need to weigh in on, so that law will get to the Supreme Court. So the Mississippi law, over the course of many years that finally the Supreme Court has agreed to see, many years ago, the court may not have agreed to take it because they would have just said it is clearly unconstitutional and could have struck it down procedurally, so to speak. But now this court has said, no, we want full briefing. We want to understand all the issues. We want everyone to be able to weigh in on it, and then we'll write a full-blown decision where all the justices weigh in. So any case, any law that involves a law passed by a state where there's an issue of whether or not it violates the Constitution, if it gets to the Supreme Court, that's the type of case that the Supreme Court will usually take and weigh in on.
Thank you for bringing that up. So let's go back to the primer part of it. So you mentioned the writ of certiorari.
Certiorari. Yeah.
Easier for you to say. So there are written arguments that each side, the pro and for and against, are going to. Who's writing the for? Who's writing the against? And when it comes to oral arguments, who ends up doing that? When it comes to, let's say, we're talking about the abortion issue right now, for example, who's actually submitting the brief that they're going to review?
So
fewer than 50 pages, I understand.
Say that again?
It's supposed to be fewer than 50 pages, that brief.
Well, are you talking about the initial brief on support of the writ of certiorari to decide whether the court will take it at first?
Yes.
Because then it goes to a full brief to decide if the court takes it to decide.
Yes, okay.
So the initial briefs are written by the parties to the case. So the attorneys for the plaintiff, the attorneys for the defendant.
Which will be?
Depends who the parties are. In some cases, if it's against the state, and it depends who brought it. So let's go back to the Texas law, for example. If that case had been challenged, which I think it was now, by the Department of Justice, the U.S. Attorney General, his office will, if it gets back to the Supreme Court, will write a brief in support of its writ of certiorari, if they're the ones who have to appeal. And the state of Texas, if they're the defendants, their lawyers will write the or don't take the writ of certiorari if they're on the other side of that. And then the case, if it's granted, the writ of certiorari back to the Supreme Court for a full brief, they'll then write full briefs, but the court will also invite what they call amicus briefs. And those are friends of the court, amicus curiae. For example, it might be a Planned Parenthood association who might want to write a brief, or it might be some anti-abortion, or whatever we would call that these days, group that wants to write a brief as a friend of the court. And so the court will direct who can write briefs and how long they can be and all of that.
And then after the written piece happens, there's oral arguments.
Right.
One each, and then you get to respond and you get to respond.
Right.
And the one who has the last word, I guess, is the one who had petitioned to have the case heard in the first place. I understand that there, and you may not need to know this, and we may not need to review it, but there are strict limits on how long they can argue and how long they can reply and when, and so.
So may it please the court, the petitioner usually goes first, and at the start, the petitioner usually will say, I reserve whatever amount of time so they can respond to what the respondent has to say. And so there are lights, actually, on the little podium where the lawyers make their argument, and it gives them, like, green, you got time, yellow, you got maybe, I don't know if it's 2-minute warning or whatever it might be, 1-minute warning, and then red, you have to stop.
Interesting. And then after this happens, there's a conference. Who's in the conference? Is that the 9 justices?
9 justices will usually, after the argument, meet, they'll discuss the argument, they'll discuss the case. They may take a preliminary vote to decide whether they're going to find in favor of the plaintiff or defendant, the appellant or the respondent. And if they then take their final vote, the chief judge will assign it to a justice to write the brief.
Let's talk about who writes the brief. We know that our justices are knowledgeable, but talk about the law clerks who clerk for these justices.
So all of the justices get to hire law clerks, and many times the law clerks will write the first draft of it and present it to the justice to review, and the justice will change or do whatever they want to that. So yes, those are recent graduates usually from law school who are very intelligent, smart, first in their class usually graduates who the justices hire. And so they actually are it's very interesting because the justice tells them what they want, but then they're writing it for the justice.
And what about after the decision's made, there's a dissenting opinion, maybe another concurring opinion, but with different reasonings. Each one is done by the law clerk and then reviewed by the justice. How does that work?
So
David?
it's up to the justice. I mean, the justices are absolutely, if they want to spend the time to write the full decision, can write their own decisions, or they can ask their clerks to write it. And so what happens is, let's just say, we're going to make this up, it was a 5-4 vote, so the Chief Justice assigns someone, if he's in the majority, to write the majority opinion, then someone's assigned to write the dissenting opinion, and many times there can be a majority opinion but with a concurrence, which means we agree with the result but for different reasons. So here's our reasoning. And there can be others dissenting for different reasons, so there can be multiple dissenting opinions too.
Good to know. I read somewhere that the justices make $286,000 a year. Does that sound about right to you?
Yes.
So speaking about the term, the money that they're making, how about the term? Supreme Court justices are there for how long? How about the law clerks?
So the term for the justices for life, I'm not sure about law clerks. I'm assuming it's at least a year, probably more, but maybe just 1 year. And I know that they hire clerks every year, so I don't know if there's a rotation among their clerks or if it's just a 1-year thing. But the clerks are not hired for life. They're in a rotation.
And what we've just heard, what's on the docket, because they're meeting. They meet from October till April, and I have some listing about they aren't around in June and July. So they actually have a very specific time. They hear Mondays and Wednesdays, or Wednesdays and Fridays, and they report out. So that's a very scheduled docket that they have. It's not just the cases on the docket, but how and when they're hearing, when they're writing, and when they're conferring is very specific.
Right, and I think the movie and the reference is first Monday in October.
Yes.
When they start meeting.
Yes. This has been very interesting to hear about the Supreme Court. We hope that it's been educational to you, and we hope that you continue to stay tuned to the Law Matters. As we say, it matters to you. Thank you for tuning in.